business owners that have opened their doors have now had a chance to kind of get a little bit more of an understanding of how they need to move forward for business. So we're just understanding that problems are arising, and that's what these sessions are really geared to address. So I just want to kind of give a little bit of an overview of how today's session is going to go. So this adaptation segment is going to be topical, and it's not, the first segment of this series was industry specific, whereas this one, because we are being more responsive to some of the issues at hand, we want to make sure that the information that our keynote speakers and our guests are providing are relevant and can cover a variety of industry sectors that may be experiencing them. So the tools that will be provided today will hopefully answer some questions and be able to tackle some of the problems that you're facing. And we're also looking to kind of move these sessions into a different format, whereby, you know, we're presenting keynote speakers or specialists in industries that have the information for the first segment. We're going to move on into a Q&A period, and I want to thank everybody on behalf of our team for submitting the questions with your registration. It really is helpful, not only to the specialists that are presenting today, but it's helpful to some of the other companies that are participating, simply because the questions that are being posed, they may not have thought of, others may not have thought of, and it provides a really robust context or information session for everybody that's involved today. From that, we're going to move on to something called a business card exchange, where we understand that traditional networking is not something that we're doing right now, and it provides a big, huge gap in developing these support systems and methods of which business owners can really connect and share best business practices and lend support to others, even if they're not in the same industry. So that's kind of the way we're shifting this segment of the Regional Resilience series. We want it to be fluid, we want it to be dynamic, and we want it to be active and engaging. So again, by all means, please make sure that if you have a question, the chat function during any point in time, please feel free to enter your information or your question there. And when we get to the Q&A, myself or my co-moderator will be sure to capture that to present it to our specialists today. And just kind of as a side note, a little bit of housekeeping, we've all kind of gotten into these virtual platforms, but just as a reminder, Zoom is a public platform, and the information that is being shared via the chat is beyond the organizer's control. So just be mindful about some of the information that you're sharing. We want to stay away from anything that's related to politics or government methodologies. This really is for practical information that can be best utilized for businesses that really need the information to help them move forward as seamlessly as possible. So, and the other thing is that with all virtual platforms, bandwidth is compromised if you have your cameras on during the presentations. So I would ask all of the participants, other than the speakers, just to make sure you keep your camera off and your microphone muted, just for ease of transition and presentation. We want to make sure that we're delivering all of the information as seamlessly as possible. So again, my name is Pam Steckler. Thank you so much for joining us. And I'd now like to welcome Bob Condon. Bob, can you test your mic again just to make sure that you're active?
Yes, can you hear me?
Absolutely. Okay. So Bob is a business development manager with Peninsula, who helped launch the services in Alberta. He has 20 years experience serving small and medium-sized businesses. So Bob, welcome and thank you so much for joining us today.
Oh, thanks very much. and maybe Pam, after I'm done, my part will only be a couple of minutes, and then I'll get Pam to introduce Ryan as well. So thanks very much for having us. I'll just put some context into why we're on this call and acting as a keynote speakers here. We're really honored and thankful to have us here. Peninsula, as Pam mentioned, I'm a business development manager based out of Calgary. However, I know the Red Deer market and Lethbridge market, everything from Red Deer to Lethbridge intimately. And normally, in any given day, we're driving and meeting clients and that kind of thing. But in this case, obviously, we're doing these remote meetings. I'll put some context around who Peninsula is very quickly, and then we'll get into the presentation from Ryan Wozniak, our Senior Vice President. So Peninsula, it's an interesting concept that's fairly new to Canada. We only launched in Canada 3 years ago. Essentially, Peninsula, we are an outsourced human resource and occupational health and safety service company, which is quite unique in our approach. We've actually been in existence since 1983. We launched initially in the UK, and from there we've expanded into Ireland, Australia, and New Zealand. And like I said, only 3 years ago launched into Canada. We're in 3 provinces, Ontario, Alberta, and British Columbia. In a very short period of time, we've assisted thousands of businesses that have now become our clients, and our delivery model is specifically designed for small and medium-sized businesses. That's a sort of quick summary of who Peninsula is. Fortunately, we had created a relationship with Community Future Central Alberta, who is now one of our clients, and hence, you know, we routinely do these webinars. And in speaking with Kelly, she thought this would be a great platform with all the other organizations that are on the call today. So again, we really appreciate it. And I'll turn it back over to Pam. Maybe she can do the quick bio introduction for Ryan, and then we'll get into the presentation and the questions and answers. So thank you very much, and we'll speak with you soon.
Thanks so much, Bob. So as Bob mentioned, we've got Ryan Wozniak. Ryan is the Senior Vice President of Operations and Legal with Peninsula. So prior to joining Peninsula in 2018, Ryan practiced employment law and commercial litigation for 12 years in Toronto. Ryan has acted in a wide variety of commercial and employment-related matters before all levels of court through Canada, including Ontario Superior Court of Justice, the Court of Appeal for Ontario, the Supreme Court of Canada, the Federal Court of Appeal, the Tax Court of Canada, the Ontario Labour Relations Board, and the Supreme Court of British Columbia, the Human Rights Tribunal of Ontario, the Canadian Rights Human Commission, and private arbitrators. Ryan is also a frequent writer and media commentator on employment law topics. Ryan's articles have been published in several periodicals, including the Advocates Journal and Just Magazine. Ryan, I have to say that I have a law background as well, and I have never seen anybody with that kind of experience. So we are absolutely pleased that you could join us today. So with that, did you want to give your mic a test and make sure that it is still operational?
Can everybody hear me this afternoon?
Great. Thank you so much. The floor is yours.
Awesome. So I'm going to start by sharing my screen. And can everybody see that? I'll try that again.
Not yet.
Oh. Okay, well, I'm going to try and, or someone, I guess someone has to allow me to screen share so I can get the slide deck up. Sorry, everybody.
We'll get Community Futures to
Sure.
make that allowance.
Sure.
So Jen, if you want to just turn your mic on, or Kelly, just to let us know.
Yeah, I'm just trying to figure out how I can do that here. I think.
Sure. I just wanted to say while you're doing that, Pam, that my hat's off to the marketing department. I always feel like I'm in a job interview when I get these introductions. They do a pretty good job of keeping it long-winded and flattering. So
it's incredibly impressive, but it just goes to speak on the specialist realm and the information that you're going to be delivering today to the group.
Sure. Sure. A pleasure to be speaking and a pleasure to have the opportunity to be here today. I know everyone is busy, and um, I used to have to ask people, I'd have to pay people to let me speak when I was a lawyer, and now I get a chance to speak for free. So let's try and see if this will work. Let's see. Can everybody see that now?
So it's noted that there we go. You're good.
Great. All right, we're cooking. So again, thank you very much for having me today. Always a pleasure to speak to business owners, big and small, especially nowadays because there are so many new and difficult questions facing business owners around the world, really, not just in Canada. And the focus of our presentation today will be preparing to reopen our businesses in a COVID-19 world. And I know it's top of mind for all of us right now. It's been a very difficult 3 months to say the least, and we're all now turning our minds to laying the groundwork for successful reopening, and myriad questions come with that discussion. So obviously, there are so many issues that are live right now. Each one of them could be a presentation in and of themselves. But today, we're going to focus, sort of my slide to move, on 6 issues in particular, which I think are most germane to business owners. And these have come out of our conversations with clients over the last 90 days. Our discourse with clients, as you can imagine, has really focused a lot on layoffs and recalls and around updating our health and safety policies and procedures to accommodate and address the risks presented by COVID-19. So we're going to start by having a very high-level discussion about updating our policies and HR portfolios to accommodate, as I said a moment ago, the risks and challenges, unique risks and challenges, and adjustments that have come with COVID-19. We're going to talk about best practices for hiring new employees. I chose to start with a positive. We'll talk about recalls and dismissals later on, but I think there are businesses out there who are going to grow their way out of this recession and are going to go back to work and reopen and are going to need new staff. So it's a great opportunity as business owners to start employing best practices if you're not already. We'll talk about layoffs and recalls, which I'm sure has been an issue for many, many of you who are watching today. We're going to talk about the less pleasant subject of dismissals instead of recalls. We'll talk about another very common issue that has come up, which is work refusals. Okay, as you can imagine, employees have been feeling safe at home last 90 days, may not want to go back to a job they didn't necessarily love in the first place, and the CERB eligibility period was just extended for another 8 weeks. And finally, we'll talk about health and safety considerations. Again, that is a topic that could be a presentation of itself. There's a lot to cover, but we'll talk about some of the main themes. So hopefully people will leave this presentation today with a sort of mental checklist, setting out what they have to do as they open their businesses or reopen their businesses or continue their businesses. Okay? The presentation should be around 30 minutes. Lawyers are terrible. We talk too much. I do try to do the best I can to be concise. I'm getting better. Can't forget I used to work by the hour, so it was a bit of an adjustment for me going corporate, but I'll do my best. And really the glue that binds this presentation together is this theme right here, which is updating our policies and procedures and adjusting our mindsets and our HR portfolios to recognize the new normal. And COVID has brought with it so many new challenges. And I'm going to identify 3. And the first of which I think is very important to know, which is new job protected leaves. And I'm not just talking about people who may be infected with the virus or may have to self-isolate or may be exhibiting symptoms and have to go get testing and take a leave of absence, which is job protected at the moment, by the way, under provincial employment standards legislation. Okay? But also, employees now have protection, job protection, when they can't come to work because they have childcare obligations or they have to care for a sick dependent because of COVID-19. So school closures, daycare closures, you have dual income families and somebody can't come back to work. And that employee now has the ability to take a job protected leave for the duration of the emergency stage of this pandemic. And the eligibility requirements are more or less non-existent. You can take it as many times as you need. There are no service requirements, unlike what I'll call traditional statutory leaves, like maternity leave or parental leave, okay? Another novel, and I say novel because prior to now, I don't think it was discussed as much as it is now. People were doing it, but certainly on the scale they are now, which is remote working. And for many of us who have physical limitations in the workplace in terms of space, we can only fit so many people into our physical workspace. Remote working may be a reality for a long time, especially in the short term, where we are going to be reopening, but have to acknowledge social distancing requirements and staggered shifts and all the rest of that. We are going to have to, most of us, if our operation or our business is amenable to it, obviously in some businesses it doesn't work, I recognize that, but this will be a reality. So how do we address remote working? How do we absence manage from afar? How do we manage health and safety from afar? We're going to talk about that in a little bit more detail later on. And finally, the big ticket item, how do we ensure our workplaces are safe? So in addition to accounting for all of the government or sector-specific guidelines and government guidelines that are being issued seemingly daily and that are constantly changing, how do we take it to the next level and ensure that we're not only complying with those high-level requirements, but also creating a safety program that's going to fit our own business model? Because of course we all have different business structures and operational matrices. So how do we do that? We'll talk a little bit more about that in part 6 of today's presentation. Right? So these are really key considerations as business owners or organizations that we have to bear in mind, okay? And of course, when we update our HR portfolios, especially now, and especially given that many employees have been away from the workplace for a fair amount of time, we have to turn our minds to training them. You know, and I wanted to mention this because it's such a simple concept, but it's so often forgotten. We make all of these changes and they're drastic and they're urgent, and for a lot of us they're immediate. We don't have a lot of time because the government says, okay, we're opening next week, as they did in Ontario last week. And people go, well, how am I going to get them ready? And we forget, oh my goodness, how are my employees going to know to do all this stuff? You know, I got to give them these new policies and give them this new information, and I got to give them some training. So when they come into the workplace, they know what to do. So it's safe, and I have the ability to enforce my rules. I can't enforce rules that people are aware of, etc. You can't forget that. Right? So we're either growing as businesses or we're continuing to operate as businesses, and we're looking to perhaps grow our way out of this recession or grow incrementally or organically, and we need to hire new employees. And how do we do that? What's the best practice? It's so simple, yet so often overlooked by businesses, big and small. I can't tell you the number of times in private practice, huge sums of money were crossed on the table over something as simple as an employment contract. The single most important document in your HR portfolio is your employment contract. Employment contract that you use with or that you have your employees sign. It is effectively your constitution with your individual staff members. And if there is ever a dispute with an employee, this will be the first place that a court or a tribunal or a lawyer goes to. Because a contract is exactly that. It sets out the terms of engagement, the relationship, the legal relationship between you as an employer or an organization and your employees and staff members. Okay? And while we have provincial employment standards legislation that implies all of these terms and sets all of these minimum standards, oddly enough, the legislation doesn't actually say you must have an employment contract. It would make sense, but it doesn't. And so beyond that, what are the key provisions? Why are certain terms of an employment contract so important? Well, for 3 reasons right now. One, termination clauses, because in this current environment, people are coming and going or hiring and firing. Economy is all over the place. We don't know where we're going to be in 6 months. We want to have that flexibility. And a termination clause provides you that in spades. And in the absence of an enforceable termination clause, employers are exposed to what's called common law notice claims if they dismiss an employee without cause. Okay, so employers often gravitate to the Employment Standards Code and say, well, here are the minimums I have to provide, not realizing that common law steps in and says, oh, and you also get this. And the benchmark is usually a month per year of service. Month common law notice or pay in lieu per year of service for an employee, right? Which can be horrifically expensive and result in really messy litigation. But an enforceable termination clause wipes that problem right off the table. And the Supreme Court of Canada has said an employer is perfectly within its right to limit an employee's entitlements on dismissal without cause to the provincial statutory minimums applicable to their business. And that's massive because you can limit your exposure by 80%, but it's got to be done properly. And they're finicky things, termination clauses, because there's usually a lot of money at stake and lawyers will want to drive a bus through them. So very, very important. And it also allows for planning. You then know if you have an enforceable termination clause that you can sit down and say, okay, I have to lay off 4 people. How much notice are they entitled to? Because the termination clause provides for a liquidated amount. You say, okay, it'll cost me X amount of money. I can exit that person from the business. Right. It's a finite calculation as opposed to what's the notice calculation, what they get in your job, is there an offset, and what's the legal cost going to be? It's going to be a mess. Temporary layoff clauses. Okay. Outside of the unionized environment, these were very rarely discussed prior to COVID. Very common in the unionized environment, right? Collective bargaining agreements usually contain very specific provisions explaining when layoffs are permissible due to things like shortages of work. They'll also lay out very specific rules for recall rights and the like. But almost non-existent in the non-unionized setting. Why? Because most small businesses or non-unionized businesses say, if I don't need this employee anymore, I'll just let them go. I'll let them go. But it's very, very important now for 2 reasons. One, we don't know when the second wave is going to come. Right? We are going to bring people back on and we might need to lay people off again, and it will happen. And if we don't have an enforceable termination clause, as we're going to discuss in a moment, or temporary layoff clause, I'm sorry, it can result in a deemed termination. If you lay somebody off with the contractual right to do so, it can be a termination. You're right back to square one. Finally, a change of working conditions clause is very critical right now because, and I saw this in the question set, we'll talk about it in the Q&A, people are coming back to work on modified terms, reduced hours, less pay, adjusted schedules, maybe working from home, and they don't like it. And they say, I've got a contract that says I can do this, or I'm entitled to that. And when an employer, in strictly legal terms, when an employee makes a unilateral and fundamental change to the terms of an employee's employment, that's a constructive dismissal. Employee can try and sue and claim termination pay. It's hard, but it's a headache. But when you have a change of working conditions clause, it gives you that flexibility because the contract will say something like the employee and the employer, or the employee hereby understands and agrees that the employer may from time to time modify their working conditions, their job duties, or what have you, as the needs of the business require. And as a contractual expression of flexibility that courts will then turn to if there's ever a dispute and say, oh, well, you kind of agreed that business might need to change things once in a while depending on how things go. It's not bulletproof, but it significantly reduces your risk. So very, very important document. Recalling employees and layoffs. I assume that many of you watching today, or at least some of you, have had to deal with layoffs. Now, this slide talks about British Columbia and Ontario. I know those of you watching today in Alberta, so we won't talk about Ontario and BC. Under the Alberta Employment Standards Code, layoffs are permissible if you as an employer have a contractual right to carry it out. It's a myth among employers that they have the right to simply lay somebody off. You need a contractual right. By that, I mean an express term and a written agreement that gives you the right to do so. You might be able to argue that there's an implied term based on past practice, but it's messy. If you have that contractual right, then the legislation steps in and governs all the other facets of layoffs, whether notice is required, how long it can last, okay, how a recall is carried out. Okay. If you lay somebody off for longer than the period permitted by statute, it's a deemed termination. and legislation, Employment Standards Code steps in and says, you've dismissed that employee, now you have to pay termination pay, and too bad, too sad. So the question then becomes, well, wait a minute, let's assume I have a right to lay somebody off. How long can I do it? Now, Alberta used to have 2 tranches. You could lay somebody off for 60 days consecutively without pay and extend it to 120, effectively if the employee agreed and you paid them. But because of COVID, the government's extended it to 120 days unpaid. However, the ministerial order that allowed for that expired on Monday. And as a result, the 30 days from Monday, this extended 120-day period will lapse. So anyone who's been on layoff, who hasn't been deemed to be terminated yet, effectively has until August 14. 2 other things I should know about layoffs in Alberta. If you recall an employee, there's actually a requirement under the statute, Employment Standards Code, that you give written notice to the employee, serve it on them, and work in 7 days of receiving the notice. And if they don't, then it's open to the employer to argue job abandonment. They didn't come back, so you can let them go and you have no obligation to pay them. Tough, but available. One other thing I should note, Alberta is unique in that there is actually a statutory requirement that you give or provide an employee notice of a layoff. Okay? If an employee has been employed with your company for less than 2 years, they're entitled to 1 week's prior notice of the layoff. If they've been employed for 2 years or more, they're entitled to 2 weeks' notice, subject to the caveat that there's no obligation to provide notice if the employer cannot do so as a result of unforeseen circumstances. COVID-19 is arguably one such circumstance, but we haven't had any guidance from the courts on that yet. Argument for sure, but no precedence yet. Okay. So we've got to bring employees back, and we've complied with our recall notices. In Alberta, you have that requirement. We'll talk about that in a minute in the context of this discussion. But it seems so simple, yet you might stop and think as a business owner, well, I got to bring people back. How do we do that? So of course, you have to start with physical distancing and workplace safety requirements. It's a no-brainer that most businesses are not going to be able to bring all of their staff back into the same place all at once, because it's not going to be possible, depending on, again, every business is different, but for the most part, you only have so much space because you've probably set up or purchased real estate based on your staffing size, and you're not going to buy more space for less people. So the reality is that we're going to have to start by saying, well, who are our most important staff? Who do we have to bring back right away? Okay. And then we want to look at objective considerations. So once we've determined who's most essential to our operation, who we need back right away, we then say, okay, well, who's next? And maybe we'll let some people go permanently. We'll talk about that next. Or maybe we might need to bring some people back and wait on bringing back other people. Granted, we don't want to run afoul of the limits on layoff periods. So objective criteria are the best way to break the tie. Sorry, my phone was stinging. I thought someone was trying to reach me about this presentation. And it's important, one, because it makes it logical and sensible for your staff. So things like criteria like seniority, historical performance data, people with historically the best performance get to come back first. Order of layoff, perhaps first out or the first back in, or perhaps we start by bringing back our full-time as opposed to our part-time staff. But it's very important for another reason. We don't want to, as employers, expose ourselves to potential discrimination claims. And we may not even realize we're doing it. So we recall people and people are coming back to work and they want to come back to work and they're keen to come back to work, and suddenly people go, wait a minute, how come everyone being recalled to work doesn't have children? Or how come everyone being recalled to work is disability free? The employer might not even realize it. Right? But to prove discrimination, you don't need to prove intent. A discriminatory practice, a practice that has a discriminatory effect on a group, can anchor a claim for discrimination. And the best defense to that is look, we based it not on these factors, but on objective business criteria. So very, very important. And again, your employees will also be less confused and more receptive to it if it's logical and sensible. They'll be clear, and they won't assume that something nefarious is going on. Okay, so very important to do that. I'm going to skip this slide because I already talked about that. I talked to you already about the recall notice requirements in Alberta. Okay, so obviously, over and above common sense, we want to make sure we comply with the legislative requirements. It must be in writing and served on the employee, right? Properly served. They must receive notice of it in writing. And the notice must indicate that they shall return to work within 7 days of the notice being served. Okay. But beyond that, when we're recalling people to work, we want to be commonsensical about it. We want to make sure that we give them enough time. That's the minimum. That's the statutory minimum, 7 days. But we want to make sure we give people adequate time to return to work. Because these things now, as we've seen in Ontario especially, the notices happen so quickly, or they're issued so quickly. All of a sudden, the government says, okay, you can open in 3 days, and employers are scrambling and they want to get up and running, they need income. But we have to be mindful that people may have been working remotely, perhaps they're at their cottages, perhaps they've traveled somewhere else during this pandemic to be with family, or maybe they need to self-isolate for a while or arrange for childcare. So we need to give them employees enough time to get back to work. Okay, and we don't want to shoot ourselves in the foot by not giving people enough time. So then we say we're open, we have customers to serve, and we'll realize that our employees actually can't get to work. What do? We're stuck. I'm a dentist, for example. I got people in the office. They need to be treated or they have appointments, and all of a sudden I thought that my hygienist was going to be able to make it. They couldn't. Now what am I going to do? I got a bunch of angry customers, right? And always communicate in writing. Obviously, you have to in Alberta by law, but it's very important to create the paper trail so that if anything goes south, you have that evidence in your file, and you're inevitably going to run into employees who don't want to come back. And we're talking about work refusals later on. So you want to make sure you create that documentary trail and make sure that you can show that you clearly asked somebody to come back to work, when you want them to come back to work, gave them an opportunity to provide feedback or raise any issues. For example, they might require accommodation if they have children or a disability, or maybe a doctor's note that says they're high risk and you have to accommodate that. You want to make sure you've provided the employee with that opportunity. Okay? And a lot of employers say, well, I gave them notice, they didn't come back, I want to let them go. And you can make a job abandonment argument. The employee didn't come back when I asked them to. I haven't heard from them. They've abandoned their job. I don't know them anything. That's an option. But you can't be too trigger happy, because if you are, it can blow up in your face and be seen as bad faith or a setup. So this is why it's so important to be crystal clear, have everything in writing, have a nice, organic, logical process, follow it, and give the employee an opportunity to provide feedback. Keep that feedback loop open, and then from an HR standpoint, you've done everything you can do in the circumstances, and you'll be well prepared if there's a dispute. Okay, so we've got employees that we want to bring back. We decided who we're going to bring back. I'm sorry. We're now in the process of, as an employer, of actually physically bringing them into the workplace. How do we ensure that it's safe to do so? Right? Well, COVID-19 testing is an option, although not widely available. Right now anyway, probably not that practical. But employers have other options. One is a medical clearance certificate. If an employee has had symptoms in the past, may have even been infected or exposed to somebody, and they acknowledge it, then a medical clearance certificate, a medical televisit, something in writing that confirms that it's safe for that employee to come back to work is an option. And a simpler option can be a declaration form, where an employee says, signs a form that begins by saying, I, John Smith, hereby confirm, or I confirm, I have to say hereby, I confirm that one, I'm not currently exhibiting any symptoms consistent with COVID-19. I have not been in close contact with anyone who's had the virus or has the virus or suspected to have the virus or themselves may have been exposed. I basically contact tracing myself. And I've also been observing public health directions regarding physical distancing and self-isolation. Okay, I've been doing everything that the authorities have been telling me to do. I've been a good citizen. And employee then acknowledges at the bottom that the statement is hereby true and accurate to the best of my knowledge, signs it, and then you've got an acknowledgement. And if there was ever an infection in the workplace where a health and safety authority showed up and asked you what you're doing to make sure your workplace is safe, or you're ever before a tribunal, you've got that evidence to say, no, look, and it's never bulletproof. People lie. Employees aren't always honest. You can't do anything about that. But you've now got a very fulsome and accurate file with documentary evidence showing that you did all you reasonably could in the circumstances to ensure the safety of your employees. Okay? Great practice. Again, I talked about this earlier. I'm not going to beat a dead horse. The importance of changing conditions of employment clause in an employment contract for this reason. As an employer, you're going to be bringing people back, modified hours, reduced pay, perhaps consolidated responsibilities or modified job duties because you're trying to keep your business running and you want the cooperation of your staff. And some will be willing and some will not. Some will say, I didn't agree to this. I want to stay home and collect the serve. Workplace isn't safe. And they're going to find any excuse they can not to come back to work, and they may use this one. My contract says I work 40 hours a week and I get this much pay and I have this job. That's what my contract says. So unless it's going to be exactly like that, I'm not coming. And I suppose it would be open to the employee to make a constructive dismissal argument, but it's tough to do because, in short, to be able to sue for constructive dismissal, you actually have to quit your job. For it to be actionable, you have to what's called accept the breach and then go sue. And it's high stakes poker for an employee because if you're wrong, you're deemed to have resigned, you get nothing, no termination pay, and you avoid your eligibility for government benefits. So a lot of employees don't like that, too much risk. They'll complain, maybe you get a lawyer's letter. Very few sue. The other thing you have to bear in mind as an employer, not that easy for employees because the Supreme Court of Canada said about 10 years ago now, in a case called Evans versus Teamsters Local Number 31, that an employee must nevertheless continue to work under modified working conditions, even if they say they've been constructively dismissed, if those working conditions aren't unduly toxic or embarrassing. CEO is now being asked to sweep the shop room floor, or something like that. Short of that, you're expected to continue working. So it's not an easy claim for employees to make. They'll complain, but legally, it's an uphill battle for employees, okay, and expensive if they have to hire a lawyer. Okay, the less pleasant conversation, letting employees go. And this is where really the importance of employment contracts comes into play. So you might now be thinking, I've got to let somebody go. I don't really have a job for them. What's my exposure? And if you're looking at a potential common law notice claim, it can be pricey. And so when you don't have an employment contract in place, there's more strategy involved and figuring out how to best position the narrative and trying to perhaps buy the support of your employee in a difficult time. But if you have an employment contract, you see your contract says this is what you get and off you go. Okay? So there's really no nice way to say this. It's an unpleasant conversation and it can be very expensive and really good to get some advice before you go down that road. Okay? So you've called back your staff, you've decided who's going to stay, who's going to go. You've taken the necessary precautions, and now you have some employees who might refuse to return to work. The key thing here is if someone's refusing to come back to work, be very clear on why that is. So there may be instances where an employee legitimately qualifies for job protected leave. They have childcare obligations, or they're quarantined, or they're ill, or they have a disability, or some legislatively protected ground under the Alberta Human Rights Act that requires accommodation, or at least a discussion on accommodation, which is, again, a whole presentation of itself can be very messy. But you want to be able to identify that so you don't just swat it away with the back of a hand and find yourself with a discrimination complaint. The more common one is going to be employees who think the workplace is quote unquote unsafe. And we'll talk about that in the health and safety section shortly. But the short answer is employees can't just sit at home and say, if I leave my house, it's not safe and I can't go to work, sorry. They have to attempt the work before they can take that position. And they don't realize it. It has to be a reasonable refusal. It can't be subjective. I can't say if I leave my house, I'm going to get hit by lightning and die. It's possible, but highly unlikely, and that will not meet the threshold, the legal threshold. Okay? And what if an employee unjustifiably refuses to return to work? Well, it's simple. That would be a job abandonment. Conceptually simple, but as we talked earlier about the recall process, practically speaking, it's a bit more nuanced, and there's a procedure and a process that you have to follow as an employer before you can jump on the argument. Okay? And if somebody, again, is seeking a leave or accommodation, it's within your right as an employer to request medical evidence, or reasonable evidence, I'm sorry. You can't ask for medical evidence in respect of COVID-19 related absences, but you can ask for reasonable evidence. Someone says, I have a disability, I can't work, sorry, bye. You're entitled to know, well, wait a minute, what is it exactly you can't do? Because I can't accommodate you unless I know what your limitations are. Again, very complicated conversation, but suffice it to say for the purposes of this presentation, to be aware of it and know that you have rights as an employer. Okay? And finally, I'm running a little bit late, everybody. I'm 5 minutes longer than I'm going to end 5 minutes longer than or later than I expected. Sorry, as I told you, the beginning lawyers talk too much. Doing my best. Health and safety. And I'm going to start by talking about work refusals, because these will probably be very, very common among businesses as they reopen. And businesses need to know this. As I said a moment ago, employees can't just refuse to come to work because they subjectively feel it's unsafe. They can't. They have to attempt the work. And if they attempt the work and it's legitimately unsafe, or they raise a refusal and the employer fails to investigate or cannot resolve it, then a health and safety authority could come in and make a determination. And the health and safety authority, Ontario would be the Ministry of Labor, and it's different across all provinces, but the point is the health and safety authority comes in and make a determination that, and they may rule that the work is actually safe and tell the employee to go back to work. And if they don't and they refuse to, that is a unjustified work refusal, and it would be open to the employer to treat that employee as having abandoned their job. Okay, and there would be no obligation to provide termination pay. But in the vast majority of cases, the employee would have to first attempt to work. The employer should make some effort to investigate. Now, it's very difficult for an employee to sit at home before they've even gone back to work and say, I'm not doing it, it's not safe. That's not going to cut it. And that's when you get on the communication chain, communication carousel, okay, as we talked about before. And you're going to encounter this as employers, I assure you, because employees have been cocooned at home. They're feeling pretty safe. They're watching the news all day. They're scared. They're getting the served. They're thinking, gee, it's pretty comfortable here. And I might even want to go back to this job. So I think I'll just stay here and, and say it's unsafe. Can't do that unless, so we talked about job abandonment. I'll skip over that. Unless, of course, you make it easy for them by not having in place health and safety policies and programs to deal with COVID-19. Because an employee could come to you and say, hey, Mr. Employer, what are you doing to make sure I'm safe? Do we have a health and safety process or policy I haven't received in a training? Or what are the rules of engagement when I go back to work? Where do I sit? How far away do I have to be from people? Employer says, oh, gee, I have no idea. I haven't thought about that. Well, I could say, well, that's not safe. You've done nothing. And they might actually, in that situation, have an argument. Not saying it'll be a successful one, but as an argument. So as an employer, we need to ensure that we've got a plan over and above the government's requirements, that we honor industry-specific guidelines, that we post our plans in publicly available places in our workspace. Okay, but we need to actually ensure that we've walked through our business conceptually, right, so that we can plan and have a health and safety plan that addresses our specific work environment. Physical distancing in a retail store is going to be different than physical distancing in a light manufacturing facility, is going to be different than physical distancing in an office, right? If you're working in an assembly plant, you can't have people in plastic cages trying to make stuff. It's not going to work. So how do you deal with that? So every workplace is different, okay? And again, the bottom line there is you really got to, great to work with an advisor to put together your system that's going to work for your workplace. Okay. Again, that could be a full day presentation, but it's not enough to just accept the government guidelines and say, okay, I've read them, I printed a sheet, posted on the wall, there we go. You have to think it through and make sure you've got, if you need PPE or decals on the floor, whatever it is you need to do, you have to turn your mind to it, because you still have an obligation, an overarching obligation as an employer under health and safety legislation to take all reasonable measures to ensure your employees are safe. Okay. And last couple of slides, what if I find out that somebody in my workplace is infected? Well, obviously, or maybe exhibiting symptoms consistent with COVID. Well, you're going to want to exit that person from the workplace. Encourage them to get tested. Tell them to take a leave of absence. Whether it's paid is up to you. They could take a statutorily protected unpaid leave. If it's a prolonged period, they have to isolate. Again, they can apply for the CERB, provided they're still eligible. And you're also going to want to do that to keep your employees confident, because it's going to spook them if anything like that happens. So you want to make sure that you encourage disclosure, accommodate that employee, act on it quickly, get that person in a place where they can get tested, be safe, and keep your other employees safe before you have a problem on your hands. Not easy, but that's why it's very important to have these programs in place. Employees will feel much more confident talking to you as an employer, disclosing these things, if they're confident in the process and the safety measures within the employer's workplace. Okay. Health and safety, very briefly, working remotely. Health and safety is hard to conceive in a virtual environment. Now, in a physical workplace, we walk around, we check it out, we can see things, we can monitor things. People are working from home, how do we do it? Well, we can't inspect people's homes, we can't go into people's houses, and there's only so much we can control. We can't control what they do in their homes. But things like checklists. Now, do they have sufficient home workspaces that are not going to exacerbate any pre-existing conditions they may have, physical or mental? Are they suffering from any kind of condition that has been worsened by modified duties at home? Those sorts of things. So we need, again, communication and training and checklists and policies. That's really important. Okay. In the same breath, just because people are working from home doesn't mean that it's a free-for-all. They can't bully and harass their coworkers. The rules regarding workplace violence and harassment still apply. Okay, we still need to investigate if there are any incidents of digital bullying or harassment from clients or coworkers. Employees can't sit at home and drink alcohol and consume drugs and put themselves at risk. If they're working alone or isolation, we want to make sure they're safe, make sure we check in on them. And God forbid, if anyone is at risk of domestic violence, we want to make sure that they're safe and take proactive steps if we're concerned that they might encounter harm. And finally, emotional support. And any of us who have EAP programs that we're providing to our employees or looking to get an EAP program, good for you. I think we talk about this a lot, but a lot of people don't do anything about it. And I don't think I'm understanding it when I say that employers and employees alike are going probably through the hardest period of their lives right now. Nothing like this has happened for a century. And it's been incredibly taxing emotionally, professionally, personally, on everybody. And we can't overlook that. And our own business has paid attention to it, and your employees will absolutely appreciate your concern for their well-being. And it'll be reflected in their dedication and their goodwill and the effort that they're ultimately going to want to make and the cooperation that they're going to exhibit in returning to work. Very, very difficult time for all of us, and we can't lose sight of that. Okay, so that's it for me. I'm sorry I ran 5 minutes over, but we have a question period now. Happy to field questions from those in the audience and have a little dialogue for the next 10-15 minutes before we get on with our respective days. And thank you for having me again.
Thank you so much, Ryan, for joining us. And the information that you covered in that presentation was extensive. And I did have a question from one of the participants. Donna wanted to know if you were comfortable with us sharing the presentation to the participants afterwards. Would that be?
Sure.
Perfect. Excellent.
Well, you know what? Check with Bob in the marketing department. I don't want someone jumping up and down, their hands in the air, but absolutely, if people found this helpful, please, by all means.
Sure,
Fantastic.
I'll check in after with Pam and Kelly, and we'll organize it.
Sounds good. So again, I want to thank everybody for submitting some of these questions, and Ryan covered a few of the questions that were submitted, but I'm just going to pose them out to Ryan. He's received what came in, but by all means, please feel free to use your chat function. If something comes to mind that Ryan maybe hasn't touched on yet, or you feel would require a little bit more of an expanded version that's specific to your business, your employees, and your situation. As Ryan mentioned, that this is unprecedented times. So obviously the problems that arise are going to vary from business to business, even though there are going to be commonalities in consistency when working through human resources issues and making sure that employees, are given the best resources, and the businesses are making sure that they're covering their bases for all the legalities that are kind of cropping up with COVID. So just kind of working on to our first question. It relates to maternity leaves, and I know that we had a couple of questions, so I'm just going to ask kind of in a group, and that way we can kind of cover. But what are some of the details around maternity leaves and employees returning? What about employee qualifying hours for maternity leaves? And what if a mat leave is due to come back, but yet you don't have a position available for them? So I'm not sure what the parameters are around that.
Pardon me, everyone. I was being a good online citizen. I muted myself. Maternity leave in Alberta is not overly complicated. It's maternity and parental leave. So to take a maternity leave, an employee must have been employed by the employer for 90 days, and then you're eligible. And then you can take a maternity leave for 16 weeks and then a parental leave for 62 weeks. And common across all provinces, it's a job protected leave and prima facie. So the assumption essentially is that you cannot dismiss the employee while they're on leave, and you must reinstate them to their pre-leave employment when the leave is over. And a lot of people think, well, that's etched in stone. Now, if a meteorite lands in my business and blows it to pieces, I have to, and I'm gone, and I have to bring this person back. That's not the case. You can let an employee go if the reason for the termination is unrelated to the leave. So what a lot of employers will do is they'll say, well, this person's gone. I got to replace them now. I don't need, I don't have to hire someone temporarily. And so we'll reorganize. And, or maybe they think, well, I always want to get rid of that person anyway. So we'll reorganize. And the person was previously the administrative assistant, but now we call them a stationary specialist, and they'll be in another department. It's the same job. They've just done it to try and move the pieces around the board to avoid being hit with a discrimination complaint. But if your business is shutting down, or because of operational concerns, like you're trying to keep the doors open, I'm not saying it's the perfect defense, but if the termination is unrelated to the leave, right, and you have a bona fide business reason for carrying out the termination, like I'm trying to keep the lights on, I think you have a good argument there to say, I haven't violated the Human Rights Act, or I haven't violated the Employment Standards Code or the Human Rights Act. I haven't done anything discriminatory, purely business related. And the virus hit, and then before I needed 50 staff, and now I need 30. And this person happened to be in a department or amongst a group of employees that were not as essential as another group of employees, so we had to let that person go. Again, as long as we talked about this, we were discussing recall rights. Now, if it's objective and it's a bona fide business reason for it, unrelated to some ulterior motive or to the leave itself, then it's a defensible position, you can do it.
Perfect. So just kind of on that note, is there a timeline associated? Obviously, businesses who are opening up are understanding how to work on a little bit more of a lean canvas or a lean model. And maybe some of the personnel that were necessary in peak times are no longer as necessary, so they phase out their position. However, 6 months from now, when business starts to pick up, are they legally obligated to contact that person again when they ramp up services again?
Yeah, well, the legislation's funny. So if you've suspended your operations, so if you've been operating your business and you said, I'm not operating at all, and I don't know how long that'll be, but you do so, you reopen again within a year, 52 weeks, I think it is, yeah. Then you technically have to contact that person who was on leave and offer them a job. I can't say that I've encountered that situation many times in my life. People generally don't like to let it go on that long. If you're wondering whether somebody who's coming back to work, you're going to need them right away, you want to buy some time, you might be able to, maybe they consent to going on layoff for 60 days while you sort your situation out. Again, that gets a bit more specific and factual. But it's moving away from the mindset that if someone's on a leave, no matter what I do, I'm landlocked. And it's not always the case.
Great, thank you. One of the next questions posed, and I think you covered it fairly in depth in your presentation, but what if my employee doesn't want to return to work for various reasons, i.e. health, family health, anxiety, etc.? I know that you touched on them, and I think that the parameters are different for each of those categories.
Well, it depends on, number one, if the reason is legislatively protected. So, for example, if I can't come back to work because I have a disability or family responsibilities, I can present evidence of those circumstances to you as the employer. And the employer would then be subject to a duty to accommodate based on a code-protected ground. And they would have to then look at whether, depending on the employee's physical or mental limitations or their children's schedules or maybe a spouse's work schedule, you have to consider things like maybe modified hours or different work schedules or maybe different job duties or modified duties on a temporary basis, up to what's called the point of undue hardship, where more or less your business can no longer tolerate it, or the detriment to your enterprise is causing the business beyond some pain. Now, undue hardship is a term of art. It's not defined. Basically, it means I can't accommodate you unless it really, really, really hurts and causes me damage. And it's a high threshold. But that's a very, when I practiced law, that was a very common issue, very, very gray. And it was great for lawyers. I can't tell you the number of phone calls and letters I wrote dealing with that. But it's complicated. So again, situations like that come up, you want to talk to somebody and work it through. Very hard to do in the abstract.
Perfect. So I've got one that has been posed on the chat from Shelley Buckland. Does the layoff period get included in the length of employment? In other words, if someone worked for less than 90 days, COVID hit, and we had to shut down the doors, and now we are able to open, are we obligated to bring that person back?
No. I'm just thinking, I don't know if this is, I think it sounds like it's a leave. If this is just someone who the employer laid off, if you don't bring somebody back within the time permitted, and you're effectively ending their employment, then it's a termination. Now, depending on the length of service, the layoff period would count towards their service length because they're still employees, they're just not working, right? So look, if it's an extremely short service employee, then they might not even be eligible for statutory pay. That doesn't mean they wouldn't be able to claim some form of common law pay. It probably would be a lot. But again, fact specific. Great to get some advice on that point. But the point is you can't use a layoff to throw someone out the door and not pay them, unfortunately.
Thank you.
It's a tough one. I know it's tough for businesses right now.
Thanks for posing that question, Shelley. Just moving on to some of the ones that were submitted pre. I know that there are mental health related issues. So as an SME, what are the key resources they can share with employees around mental health supports if they are feeling stressed or anxious? And I know that you touched on employee assistance programs, which a lot of companies don't pay into EAPs. So is there anything that you can think of off the top of your head that may qualify? And employees legally obligated to provide some sort of support around mental health, given that COVID is this completely different situation that we've never experienced before?
As it stands now, no. Employer doesn't have an obligation to provide EAP support to staff. But in terms of resources, I mean, there's lots of private vendors, and sure, there are lots of EAP programs out there, government resources. To be perfectly honest, I haven't spent a ton of time in the EAP space. Having worked in law firms, I can tell you, EAP programs were unheard of. Our business in the UK has a whole division called Health Assured. We provide EAP programs to small businesses, and it's a much more mature market. The HR advisory market's much more mature in the UK. But that's probably a good question maybe to take up with maybe an insurance broker. Brokers deal with that. Government resources. A lot of brokers out there will be able to source you with affordable programs. That you can take advantage of. Maybe bundle it into your insurance portfolio, and your employees will appreciate it.
Thanks. I think Art's posed a question just related to mat leave again. So maybe we'll just get some expanded information. What if an employee has been on maternity leave and at the end of the leave period, there is no job position to return to? What is the obligation for returning from maternity leave? And I know you touched on it, but maybe just some additional detail with regards to the parameters around that.
Sure. I guess it depends why there's no job to return to. If you can't return, if you're saying there's no job to return to because your business had, as I said before, 40 employees and you've deemed 15 to be unessential to your operations, and you have financial and budgetary restrictions, then I think you have a good argument to say, no, I don't have a job for that person, and there's a legitimate business reason for it. If the reason is I don't want them back, or something vague like I don't want them back, or really they're a terrible employee, or I'm going to give the job to somebody else and restructure, that will be an issue. Again, it's all about, always having a very concise and clear business case for that. And look, if somebody historically had very poor job performance just before they want to leave, maybe on the cusp of getting dismissed for term or for performance reasons, and a leave doesn't shield you from that, right? If you otherwise be disciplined, that's an option as well. Again, very fact specific, but as I said before, just because someone's on leave doesn't mean they're completely bulletproof for forever.
Fair enough. And I guess that really comes down to case specific circumstances. Sure. And the common thread that I think the participants are picking up on here is documentation is the key. And it really provides security for communication for both the employer and the employee. So document. One of the next questions that's posed, and I know that this is probably in the back of most people's minds, is the employer liable if there is an outbreak in their place of work? So what are the implications related to that?
I think, sorry, Premier Ford Ontario was speaking this morning, and there was a comment broadcast on the news this morning that the province is considering enacting legislation that would provide immunity to businesses from claims that they've endangered their staff, because really and I get that they don't have control over it, right? We can't control a pandemic. We can't control what a virus is going to do or other people do. So I'm not aware off the top of my head whether the government of Alberta is doing a similar thing. But I think it would be, regardless of whether there's actual legislation in place, I would think it would be very hard to argue that an employer is somehow responsible, either in the context of a workplace workers' compensation benefits claim or tort or negligence claim, for exposing somebody to COVID, unless they were grossly negligent. And that's what Premier Ford was talking about. He said, well, short of gross negligence, what do we want businesses to do? So gross negligence would be you knowingly, either you're reckless or you're grossly negligent, where you think, well, someone told me there might have been someone in the office who's sick, I just ignored it. Or you do absolutely nothing to make your workplace safe and demand people to come back, or you're aware of someone who tested positive, you did nothing to prevent them from coming in. And short of that, or you've basically been dumb as an employer or just flat out ignorant, I think it's going to be very hard for anyone who tries to successfully pursue a claim against a business, especially a small business, that they're somehow responsible for the spread of a pandemic effectively.
So, and that's really great information. So the burden of proof really kind of remains to prove negligence on the employer's behalf in order to kind of.
Yeah, I think it'd be a very, very high bar, very high bar.
Yeah. Do I have to offer employees the same shifts that they had before opening if opening requires a different approach with respect to operational hours?
That ties right into our conversation about changing working conditions, and you don't have to technically. Employee has a contract, whether it's written or not, and they've always worked 9 to 5, Monday to Friday, making X amount an hour. And you as a business go to that employee and say, I'm either recalling you or we're just not that busy. In order to keep employing you, I'm going to have to hire you on 25 hours a week, Monday, Wednesday, and maybe Saturday mornings, just speaking hypothetically here. And I really need your assistance. And the employee says, no, sorry, not interested. They have the option, then I guess, of pursuing a legal claim, because they have to make a choice. You're going to say, well, I need you at work or I'm going to find somebody else. And if they said, I'm not doing that, sorry, you as an employer are going to say, well, I need you into work. Sorry. Employees will say, no, but I'm only going to work on these terms. So you're going to claim cause as the employer, and they're going to claim constructive dismissal as the employee. And I think in that situation, it's not an easy one, that as an employer, you're I think, well positioned to say, first of all, be honest with the employer, explain why you're doing it. And if they ever turned around and said, sorry, you constructively dismissed me, I'd say, no, you didn't. You abandoned your job because I asked you to come in and mitigate. And employers now are probably going to get more sympathy in those circumstances than they ever would pre-COVID, because any court or tribunal, in my opinion, would look at this and say, what do you want this business owner to do? They've got a life too. They've got bills to pay and they got to earn income. And they're trying to do what they can to give you a job and keep their business running. And you're saying, no, it's all about me, 100% or I'm out. And I think business owners in that situation, if they do it properly, again, this comes down to documentation, making sure you paper the conversation, explain the reasons, be transparent and you're honest with your employee, give them the business reason for what you're doing, ask for their cooperation, they thumb their nose at you and say, no, I get 100 cents on the dollar or else. I think you're in a good position as an employer, to say, no, this employee walked away from employment because they were greedy. And if you ever got sued, I think you have a good defense.
Perfect, thank you. I know that we're kind of getting close to the edge of the time, but I think there's a couple of questions here that, especially this one, that would be really relevant because it's new. And now after experience COVID, should there be a pandemic procedure in our company's policy and procedure manual?
That, yes, I don't know if I have to call it a pandemic procedure per se. You would definitely want to have a procedure in place to address the potential presence of infection. So if somebody is exhibiting symptoms or maybe multiple people, you find out that a couple of people were in an environment or maybe in a workspace or someone gets infected and 10 people in that division were exposed to that person. You then have to, there's a quarantine, you have to have a process for quarantining and isolating and perhaps even shutting down temporarily to extract that risk from the workplace. So you absolutely have to have a process for dealing with that scenario. We hate to think about it, but Health and Safety Authority could come in and shut you down anyway if there's a risk. Well, first of all, if there's an infection, the public health authorities are going to come in and investigate. You can be certain of that. You very well might be shut down anyway. But you want to make sure that but you don't want to have a bunch of authorities come in and they say, okay, well, how did this happen? Do you have any procedures in place? Oh, no, sorry, nothing. They go, well, no wonder you haven't, and then you might have a problem, right? Because then they could say, well, you need this, and why didn't you do that? I'm not saying you'd be prosecuted if you're doing your best, but if you did nothing, could attract some risk.
Perfect, thank you. So I think that you have covered such an entirely broad spectrum of the issues that businesses are being faced with, as we move forward to opening the economy. So on behalf of the companies participating in this session, as well as the Regional Resilience Group, I want to thank both yourself and Bob for joining us today. And like Bob said, we'll connect post this session to make sure that we can share out this information. But again, thank you so much. It's incredibly valuable to have the information as we're kind of moving into the next phases. So unless anybody has any additional questions for Ryan, we're gonna thank him again.
Thank you very much, everyone. Real pleasure interacting with all of you, and have a great afternoon. Thank you. Okay, bye-bye.
Bye. So folks, thank you so much for participating. And as I mentioned at the start of this session, is that we're really moving into sharing the information that is relevant and in real time with the needs of the economy moving, opening back up into the next phases. So, but what we're identifying is that the opportunities to connect with businesses to really share best business practices and really share information on how to best deal with some problems that we've never experienced before. We wanted to open up the floor to businesses to kind of really have a really broad open dialogue. And what I would like for everybody to do that's on the call is to share your virtual business card on the chat function. Because I think it's important to share the businesses, who you are, because as we move forward, it's important that businesses stay connected in order to be able to support one another in light of how we're taking steps forward. We don't know if a second wave is going to hit, but sometimes some of these connections can really help with creating strategies on moving into the next state of, I'm going to use the word normalcy really loosely, but taking the next steps. So if everybody wouldn't mind sharing your information in the chat, and by all means at this point, if you want to open up your cameras and your microphones. Again, if you have any questions, you want to share information, the organizers of this session, we would love to hear real-time feedback on what you thought of this session, whether you thought it was valuable, So the floor is the participants' realm now. So was there anybody that wanted to kind of speak freely and take the mute off their microphone and kind of share who you are? And all right. So, well, we are, there we go. So we've got Kelly sharing some information with regards to Community Futures. And I just want to make mention that Community Futures, Central Alberta Economic Partnership, Access Prosperity, the Central Alberta Regional Innovation Network, the economic development community throughout Alberta, including the city of Red Deer, are fantastic resources. I do know that one of the questions that was posed earlier was, now that businesses are coming back online, how can municipalities who have no funds help the business communities who are struggling to finance their reopening? I didn't pose that question to Ryan because it didn't fit within his parameter of his scope of information because we wanted to work with the human resources issues. But the team and the group that are putting together these regional resilience sessions have access to information that is in real time, that is directly relevant to resources available both provincially and federally. And if you haven't yet done so, please reach out to your community and your economic development officers, because the ongoing dialogue is really what's going to help move this process so businesses survive this current situation, and we can all work a little bit more connectedly to make sure that you have access to the resources, especially with some of the rural areas and municipalities. So I just wanted to share that. And I see the information is being shared on the chat. So by all means, everybody in part with these sessions is here to help the businesses to make sure they thrive and succeed, and we can move on into phase 3. So I'm not sure if anybody wants to open up their mic and share any information, or maybe even some just like an open communication on if there's anything that you felt content wise should be addressed in the future. I know we've got some sessions coming up throughout the summer, and the next one is scheduled for July the 14th, and we'll be sending out details, but that is really specific to health and safety in the workplace. But feedback is really important for our team to be able to get the information that the businesses require. And with your feedback, we can make sure that we're researching the best specialists to come and present, so the most accurate and up-to-date information is out there. All right. I see we have a talkative bunch today. So I think that will conclude today's session. I want to thank everybody for joining us today. We hope that you found this session as informative as we did. We are, like I said, I will be connecting with Bob following this, just to ensure that we can share that presentation around. And if anybody does require some information with regards to legal remedies or whatnot, by all means, please contact any one of us. We're more than happy to link you in to our contact base to make sure that we're finding you the right connection point. So, and I'm gonna quickly go ahead and just share my information as well, because I see the rest of our team has gotten that. So by all means, contact me directly as well. So with that having been said, thanks everybody for joining us today. Oh, when is the next session? So July the 14th. And we'll be sending out additional information via social media platforms and health and safety. So. All right, folks, enjoy the rest of your day.
Thank you.